Court will call 25 CF 2981, State of Wisconsin versus Brittney Luther. Appearances.
ADA Sam Smith for the state.
Ms. Lowther appears in person in custody along with counsel, Attorney John Orth.
Morning, Counselor. Did you receive a copy of the criminal complaint?
I have waived reading and stand mute as to the misdemeanor.
Is the address on the front of that complaint the best mailing address for Ms. Luther? Yes. I have reviewed the criminal complaint. As to count 2, I did make a probable cause finding and enter a not guilty plea on her behalf. State's position on bail.
State's recommending a signature bond along with the conditions that she not operate a motor vehicle and not consume or possess alcohol.
Any objections?
Your Honor, I would ask for the condition to be not operate a motor vehicle with any amount of alcohol or controlled substances. She, her last prior is 10 years old, approximately. She has no other criminal history. I think no drive is a step too far.
Any response, Counselor?
Nope.
Reviewing the criminal complaint, looking at the age of the prior, I will order a signature bond. I will order that you not operate a motor vehicle without a valid license or after the consumption of any alcohol. I will also order that you not consume or possess any alcohol during the pendency of this action. Time limits as to the preliminary hearing.
Will waive.
Those are waived. A status conference shall be scheduled. We are adjourned in Ms. Luther's case. Good luck to you, ma'am.
All right,
Thank you.
this way, please. Next is Alan Jensen.
Oh, yeah, on the other side of the window.
Jensen. Stand go ahead.
Here's a copy of it. So
Court will call 25 CF 2987, State of Wisconsin versus Alan Jensen. Appearances.
ADA Sam Smith for the state.
Mr. Jensen's here in person with counsel Bill Ginsburg. We got a copy of the complaint. Waive its reading. That address is correct.
I have reviewed the criminal complaint as to Mr. Jensen and alleges 2 felony charges. State's position on bail.
State's recommending a signature bond along with the condition that he not consume or possess controlled substances or drug paraphernalia without a valid prescription.
Any objection, counsel?
He can't hear anything, so I'm gonna talk real loud and tell him, let's say what happened. So they want a condition of bail that you could sign a signature bond. Okay, but no drugs and paraphernalia while the case is pending, okay? Yes, no objection.
Do you want it noted that he needs hearing aids for future proceedings?
Yes,
I think in a prior case, he had a real-time interpreter. Usually I sit behind the court reporter and watch them type,
he can read lips.
read what's going on. I'll mark the case for that. Thank you.
I will then give you a signature bond. I will order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. Time limits as to the preliminary hearing, counsel.
We'll waive time limits.
A status conference shall be scheduled. Time limits are waived. We are adjourned. Good luck to you, sir.
All right, Mr. Jensen. We're gonna get back in here for the moment. Next is LUILLY Perez Dun. Good sight. There's done. Oh, he's loud. All right. Very good. Right down there.
Hello.
Perez Dun. The victim is requested an interpreter for this case, so it'll have to be consecutive. Everyone will need to remember to keep their thoughts a little bit shorter than usual.
Court will call 25 CM 3083, State of Wisconsin versus LUILLY Perez Dun.
Se llama el caso de la Fiscalía de Wisconsin 25 CM 383 contra Luigi Perez Dun.
Appearances.
Comparecencias.
ADA Sam Smith for the state.
Comparece el fiscal Sam Smith de parte de la Fiscalía.
Adam Welch from the Public Defender's Office for Mr. Perez.
De parte de la Oficina del Defensor Público, de parte del señor Pérez.
Mr. Perez has been provided a copy of the complaint.
Se le ha entregado al señor Pérez una copia de la denuncia.
We will waive reading. And, pardon me, the address on the complaint is correct. He does qualify for public defender assistance.
I have reviewed the criminal complaint.
He revisado la denuncia penal
I do make a probable cause finding and enter a not guilty plea on Mr. Dunn's behalf.
y determino que hay motivo fundado y haciendo declaraciones de no culpabilidad de parte del señor Pérez Dun.
I believe there may be a victim who wishes to make a statement.
Parece que tal vez hay una víctima que desea hacer una declaración.
If you are here on the Perez Dunn matter, please unmute yourself and state and spell your name.
Si está presente para el caso Pérez Dun, por favor active el micrófono, diga su nombre y deletrelo.
*6 to unmute from a phone.
Si está en un teléfono, asterisco 6 para activar el micrófono.
If you are here on the Perez Dunn matter, please unmute yourself
Si está acá para el caso Pérez Dun, por favor active el micrófono.
*6 to unmute if you're on a phone.
Si está en un teléfono, presione asterisco 6.
I'm receiving word. I think it may be difficult for some people to hear the translation on the live stream.
Parece que para algunas personas es difícil escuchar la interpretación.
If you are here on the Perez Dunn matter, please unmute yourself and state and spell your name.
Si está acá para el caso Pérez Dun, por favor active el micrófono, diga su nombre y deletréelo.
*6 to unmute if you're on a phone.
Si está en un teléfono, presione asterisco 6 para activar el micrófono.
Attorney Smith, any information on if there's a victim wishing to speak?
Abogado Smith, ¿alguna información acerca de si hay alguna víctima que desea hablar?
We were given notice that someone wanted to speak. That's all the information that I have for now.
Toda la información que tengo por ahora es que había alguien que deseaba hablar.
We've given multiple opportunities for anyone who is wishing to speak on this case, having heard nothing.
Ya hemos dado varias oportunidades para alguien que desea hablar en este caso, pero no hemos escuchado nada.
State's position on bail.
¿Cuál es la posición de la fiscalía en fianza? Should I switch to consecutive or keep?
An excellent question. Maybe just to be safe, we should continue.
Sounds good. ¿Cuál es la postura de la fiscalía para la fianza?
The state's recommending a signature bond,
La fiscalía está solicitando una fianza juratoria
along with the conditions that the defendant have no contact with Laura P.J.
con las condiciones de que el acusado no tenga ningún tipo de contacto con Laura P.J.
Laura, and the last initials P.J.
Laura P.A.U.R.A. y las iniciales P.J.
along with a ban from the 2000 block of Pike Drive.
Y que tampoco pueda estar presente en la cuadra 2000 de Pike Drive.
And lastly, a condition that the defendant not possess any dangerous weapons.
Y por último, la condición de que el acusado no posea ningún arma peligrosa.
Defense position on bail.
La postura de la defensa para la fianza.
I need to speak with Mr. Perez for a few moments.
Necesito conversar con el señor Pérez por unos momentos.
I know that can't be done very quietly, so I'll mute the live stream while you're having that conversation.
Sé que no se puede hacer con mucho silencio, entonces voy a desactivar el micrófono.
Thank you, Judge.
Gracias, jueza.
We have no objection to the requested conditions.
No nos oponemos a las condiciones que se solicitaron.
Then I will order a signature bond.
Entonces voy a ordenar una fianza juratoria.
I will order during the pendency of this action, you have no contact with Laura PJ.
Voy a ordenar que mientras esta acción esté pendiente no pueda tener ningún tipo de contacto con Laura PJ.
You can't call, write, text message, no contact whatsoever.
No puede llamarla, escribirle, enviarle mensajes de texto, ningún tipo de contacto.
A ban from the 2000 block of Pike Drive.
No puede estar presente en la cuadra 2000 de Pike Drive.
And that you not go armed with any dangerous weapons as defined by statute.
Y no puede tener ningún arma peligrosa según lo definen los estatutos.
We are adjourned.
Se levanta la sesión.
Next is Harry McCormick. Thanks, Natalia.
Have a good day.
Mr. McCormick? Down the yellow X.
Roll call 25 CF 2946, State of Wisconsin versus Harry McCormick, appearances.
ADA Sam Smith for the state.
Mr. Harry McCormick appears in person in custody with counsel attorney David Anderson. We have received a copy of the criminal complaint. I do believe that the address is correct. And I would challenge probable cause as to counts 1, 3, and 4. Count 1, second degree reckless endangering safety, based on the 4 corners of this complaint. I'm assuming they are referencing under the section on page 4, shots fired, where Deputy Fell was outside of the building. They were aware that Mr. McCormick was in the basement of that building and heard what they believed to be 3 gunshots. There's no other information on where those gunshots went, whether or not it was in fact a firearm that made those noises, or that there was anyone who was actually in danger, or that Mr. McCormick would be aware was in danger or reasonably be in danger. And I think that goes contrary or right along with count 4, where that requires that Mr. McCormick intentionally discharge a firearm into a building. If the officers are outside of a building, theoretically, he would have to be firing outside of a building, not into a building. Finally, count 3, threatened to cause bodily harm. The only thing I can find is again on page 4, where they heard him repeatedly scream, "Fuck you, go away, eat shit and die." I don't think that is sufficient for a finding of an actual threat to law enforcement.
Counsel.
I'll start by noting under the heading Attorney Anderson reference to the shots fired heading, we see that Deputy Fell asked the defendant to come and talk to law enforcement at the front of the house several times, or at least one time. The responses of "fuck you, go away, eat shit and die," and then subsequent or the paragraph immediately below that of the 3 loud gunshots, that at least the way I read it, I think it appears to be at least close enough in time that there's an inference that it is in response. And in response to the law enforcement officers present there on scene. So I do think there's sufficient probable cause for counts 1 and 3 as to the discharging a firearm into the building. Again, I think based on the information about the 3 consecutive shots being fired under the heading shots fired there, I think there is probable cause for that as well.
Response.
On the timing between the comments alleged by the defendants and the thoughts and the shots that were alleged to have been fired, we don't know the time in between there. It's all speculation and can't be discerned from the criminal complaint. Again, there has to be a finding that someone, that Mr. McCormick or anyone in that situation reasonably knew that he was putting someone in criminally reckless or endangering safety by criminally reckless conduct, and it requires a finding that he would have been aware of where these officers were. All we know is that someone was outside the building yelling in, presumably from the facts of the complaint, and that Mr. McCormick was somewhere downstairs. No one could see where he was. He couldn't see where anyone else was. And that is not sufficient for a finding of criminally reckless conduct. And certainly on count 4 requires that he is shooting into a building. And that is not what we have here. That statute does not apply to someone who is inside a building. And if anything, if people were going to be endangered, that means he would have to be firing to outside the building. And I still stand by the lack of actual threat on count 3. And I'm sorry, on count 4, there has to be realize that there was a human being present inside the building. We don't have any of that here. And I will note the jury instructions on the count 4 on footnote 1. Into means from the outside to the inside of. Shooting into the house occurs when a bullet penetrates the outside of the house or building, however slight the penetration.
Does it specifically say when a bullet penetrates the outside of the building or when a bullet penetrates the building on that jury instruction? Because on the footnote for the jury instruction underneath the statutes, it says when a bullet penetrates the building.
So
Outside isn't in there in that jury in the statutes.
So I don't know what the statute saying. This is citing State versus Grady.
Yes.
And it says before that last paragraph that I said, it says into means from the outside to the inside of, advancing or continuing forward. And then it follows, a shooting into a house occurs when a bullet penetrates the outside of the house or building. And however slight the penetration, it does not require that there be any set distance of penetration, but it still requires it to be shot into from the outside of the building. And this is from jury instruction 1324.
Based upon the defense motion, I will dismiss count 4, as there's an insufficient basis on the 4 corners to believe that there was an intentional discharging of a firearm into a building. However, taken in its entirety with the statements the defendant was making, with the officers hearing the gunshots and the conduct surrounding the situation, the statements "and die" and the gunshots around, which occurred during that same time frame as alleged in the complaint, I do believe there is a sufficient basis for count 1 and deny the motion to dismiss. I also deny count 3 when taken as a whole. As alleged in the criminal complaint, I do believe there's probable cause based upon the defendant's statements, the officer's recitation of the gunshots, and the conduct surrounding the situation in its entirety.
With that, we would enter not guilty, please, to any misdemeanor counts. And we will not waive the time limits.
As to counts 5 and 6, I will make a probable cause finding. I will enter not guilty pleas on Mr. McCormick's behalf. State's position on bail.
There is a victim that wishes to be heard in this matter.
If you're here on the McCormick matter, please unmute yourself. *6 to unmute if you're on a phone.
I
You are
just
here.
to say,
Hold on. Are you
Yep.
here on the McCormick matter, ma'am?
yep,
Please state and spell your name.
Tammy Anderson, TAMMYANDERSON.
This is your opportunity to tell the court what you think I should do in regards to setting bail here today.
I think he doesn't deserve bail.
The court will set bail. Are there any conditions or anything that you are requesting in regards to bail?
Not particularly.
Okay, thank you, ma'am.
Thank you.
State's position on bail.
State's requesting cash bail in the amount of $250,000, along with the conditions that the defendant not possess any dangerous weapons, that he have no contact with Tammy A. It's TAMMY, last initial A is an apple. That he not consume or possess alcohol. And that he be ordered to not leave Dane County during the pendency of this case. I would also ask that if he does post whatever amount the court sets today, that he be referred to pretrial services for GPS monitoring. In regards to the significant amount of cash the state's requesting, we did touch on the facts a little bit in the defense's motion to dismiss a few of the charges. I'll just note for the record, this is a case in which the defendant's alleged to have shot a firearm in the vicinity of officers. There's also alleged threats to his girlfriend with both a gun and a knife. There was a relatively long period of negotiations with police, and the defendant didn't ever really seem to comply with law enforcement. For all those reasons and all the very concerning conduct in the complaint, the state feels significant cash bail is appropriate.
You asked for GPS monitoring, but you gave no banned areas.
It's my understanding I could ask for is in regards to the condition about not leaving Dane County.
So there's no specific, no contact addresses that you want?
Just one moment, Your Honor. The 4800 block of Kirkwood Drive. It's in the town of Westport.
Counselor.
First, in response to the 4800 of Kirkwood Drive, that is Mr. McCormick's residence. I do not believe that TA resides there or has a lease or anything of that nature. We certainly object to the not leaving Dane County. I don't see a reasonable basis for it. There's been nothing laid out that why Mr. McCormick is a flight risk. He doesn't have any history of not appearing. Certainly the court has found probable cause on some felony charges, but I would argue that the amount of probable cause is fairly low, and Mr. McCormick has retained counsel. He is employed. He does live in the Dane County area and has for some time. He has family and support. There's nothing that indicates Mr. McCormick would not appear for court. I do also object to the amount. It is a very significant and unreasonable amount of $250,000. I think an appropriate amount of cash would be around the $2,500.
Your Honor, if I may add just one more thing, I apologize. My office does also, and law enforcement has information that the defendant did inform Tammy A that there were plans to leave the country. So obviously I understand the defense should be able to respond to that, but that's additional information I did not include in my initial bail argument.
Any additional information regarding Tammy A's contact or ties to 4800 block of Kirkwood Drive? I see that's the call to service originally. Does she live, reside, have claim over that area?
I don't believe so.
What's the basis for the no contact with that area then?
Where the incident occurred. I believe at one point that person did stay there, but no longer resides there.
Okay. Response to leaving the country.
I don't have any response. This is some allegedly coming from TA. We dispute it.
Given the information that's in this complaint, the allegations that are alleged, the conduct that's alleged is extremely serious. I do believe high cash bail is necessary to assure Mr. McCormick's appearance at court. I will set cash bail in the amount of $200,000. I will order that he have no contact whatsoever with Tammy A, that he not go armed with any dangerous weapons as described by statute, that he not consume or possess any alcohol while this case is pending, and that he not leave the state of Wisconsin while this case is pending. I will not order any GPS monitoring as there's no specific ban area. Time limits as to the preliminary hearing, I think you said you did not waive those, Counselor.
That is correct.
Those are not waived and the preliminary hearing shall be scheduled timely. We are adjourned in Mr. McCormick's cases.
Right, just fine. Next is Gilbert Richards, appearing via Zoom.
That's Daryl Jensen. No, that's Daryl.
Court will call 25 CM 3084, State of Wisconsin versus Gilbert Richards, appearances.
Sam Smith for the state.
Attorney Adam Welch from the Public Defender's Office appearing on behalf of Mr. Richards. Mr. Richards, is that you on the video?
Yes, sir.
Okay, Mr. Richards is appearing by Zoom video from elsewhere in the jail, I believe. Mr. Richards, do you have a copy of the complaint in this case?
Yes, sir.
Okay, we'll waive reading of the complaint. At this time, I have the job center at 1819 Aberg Avenue, Madison, Wisconsin, 53704 as a mailing address for Mr. Richards.
I have reviewed the criminal complaint. I do make a probable cause finding as to counts 1, 2, and 3. I will enter a not guilty plea on his behalf. State's position on bail.
State's recommending cash bail in the amount of $500, along with a ban from Comfort Suites, and that he not consume or possess controlled substances or drug paraphernalia without a valid prescription. Reason for the $500. Looks like the defendant had a active parole warrant at the time of this incident, and then it's alleged that he resisted arrest. For those reasons, the state feels some cash is needed.
Counselor.
Your Honor, I don't believe that's a reasonable basis for a cash bail. There's no information about what this warrant was or the validity of, the allegations against him, why this warrant was put out in the first place. From what I can see, Mr. Richards has no failures to appear in any recent cases. The nature of these allegations, in my mind, doesn't call for a cash bail generally. I think a signature bond would be more appropriate.
The complaint alleges 3 misdemeanors. The conduct is not overly severe. However, there is non-compliance with officer's command, which does give the court pause to see if he will attend at future court dates. However, I've heard nothing about missed court appearances. Taking all of that, I will give Mr. Richards a signature bond. I will order that he is banned from Comfort Suites and that he is to not use or possess any controlled substances or drug paraphernalia during the pendency of this action.
Next is Chandler Weir. Weir. You stand on the yellow fence.
We'll call case numbers 25 CF 1861 and 25 CM 1679, State of Wisconsin versus Chandler Weihert, appearances.
ADA Sam Smith for the state.
Ms. Wyatt appears in person and in custody with Attorney Adam Welch. We've received a copy of the criminal complaints. We will waive their reading. The address on the complaints is accurate, and she does qualify for a public defender.
I have reviewed the criminal complaint in 25 CM 1679. I do make a probable cause finding and enter a not guilty plea on Ms. Weihert's behalf. State's position on bail.
Start with 25 CF 1861. In that case, the state's requesting cash bail in the amount of $7,000, along with the conditions that she not operate a motor vehicle. I'll note, or I'll start with a history of missed court appearances. Bench warrants issued December 22nd, 2021, February 15th, 2022, May 6th, 2022, August 15th, 2022, October 11th, 2022. And I believe August 7th of 2024. Given the allegations specifically relating to fleeing and eluding law enforcement and the failures to appear, I think a significant amount of cash is appropriate in that case. I'll also note the defendant is currently on extended supervision in 23 CF 520. The status is listed as absconded. As to 25 CM 1679, the state is requesting $1,000 cash and no contact, or rather a ban from Von Mar. And reason for the cash is the same that I mentioned in the earlier cases, being absconding from ES and the failure to appear history.
Counselor.
Thank you, Your Honor. So the misdemeanor cases, I mean, it's about the lowest level kind of case you can get. It's a retail theft of less than $500 worth of merchandise alleged. And the felony case is also the lowest level, or almost the lowest level felony you can get. It's a class H felony for attempting to flee a police officer. These are low-level cases, and I don't think the amounts of bail that the state is asking for are really appropriate. I understand the request for cash bail based on prior failures to appear, but for one thing, Ms. Weihart is currently indigent. She has been injured. She has, you can see she has her cast of some sort on her hand. She's been unable to work. So she's not going to be able to post any significant amount of cash. And for another thing, she is on extended supervision right now. So one or two of two things is going to happen. Either they'll pursue revocation, in which case the bail decision is going to be moot for the time being. Or if she is released, which is the only situation where the amount of bail would actually matter, she'd be released on supervision with some sort of, I would assume, plan in place to monitor her. So I don't think it's reasonable to set cash bail in the amounts requested by the state. I would ask the court to consider a much lower amount. Thank you.
25 CM 1679, or actually the state mentioned 6 failure to appear since 2021 and didn't even mention the one September 18th of 2025 in 25 CM 1679, where Ms. Weihart had actually posted $200 cash bail, then promptly failed to appear, and that $200 is now been forfeited. Given the multiple failure to appears, the eluding conduct that's alleged, and the recent failure to appear in one of these pending actions, I do believe cash bail is necessary. In 25 CF 1861, I will set cash bail in the amount of $3,000, and I will order that you not operate a motor vehicle. In 25 CM 1679, I will set cash bail in $500, and I will order a ban from Van Mar. Time limits as to the felony matter.
We'd ask for a prelim within the time limits,
A
please.
preliminary hearing shall be timely scheduled. We are adjourned on Ms. Weihart's cases.
Next is Reggie Trumore. Reggie Trumore, your paperwork, please send the ones.
Roll call 25 CM 3073, State of Wisconsin versus Reggie Trimborn, appearances.
ADA Sam Smith for the state.
Attorney Adam Welch with Mr. Trimborn. If I could just have one moment. Thank you, Your Honor. Adam Welch appears with Mr. Trimborn. He appears in person and in custody. The address on we've received a copy of the complaint, waive its reading. The address is accurate. He has applied for a public defender and it's pending verification right now, so we'll get back to him. when we have that figured out.
I have reviewed the wait, please. I have reviewed the criminal complaint. I do make a probable cause finding. I will enter a not guilty plea on Mr. Trimborn's behalf to the misdemeanor charges as alleged. I understand there's alleged victims who wish to make a statement. I think they've unmuted themselves. If you're on the Trimborn matter, if you could please state and spell your name for the record.
Okay, I'm his mom. I'm Cherie, Cherie, Trimborn, Trimborn.
Ma'am, this is your opportunity to tell the court what you think I should do in regards to setting bail.
We're concerned he needs mental health counseling. He needs drug and alcohol counseling. We've dealt with this matter for almost 20 years. We love him dearly. What else, honey?
Wow.
We live in Jefferson County.
We would basically like,
Oh, sir, can you please state and spell your name too, the court
Okay,
reporter?
yes.
my name is Randy, Randy, Trimborn, Trimborn. I am his
Okay.
father. We love that young man, but we want to get him help. If you are gonna turn him out, we would like to know when we can pick him up. Other than that, we would like his conditions set as no alcohol and no drugs, and to try to get mental and alcohol and drug counseling. And we also would like to have him to have no contact with any past drug houses or relationships with his drug friends. I don't know. We need him back. He's got court cases coming up in Jefferson County too. His last week has been
Terrible.
a hell week. And that's why we brought him to the hospital when he was arrested for this. So, but I don't want him kicked out in the cold in Madison. We want to come get him if we can. So if you're going to turn him loose on a signature bond, please let us know. That's all I got to say. I thank you, Judge.
Thank you. The court will take all your statements under advisement when setting bail.
Thank
What
you.
is this? What is the state's position on bail?
The state's recommending a signature bond along with the conditions that the defendant not consume or possess any controlled substances or drug paraphernalia without a valid prescription, and that he not consume or possess alcohol.
Counselor?
We have no objection to those.
I will then give Mr. Trimborn a signature bond. I will order as conditions that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. You are not to use or possess any alcohol during the pendency of this action, and you are not to direct any acts or threats of violence towards Sherry T. or your father. Can't remember his first name. Randy T. We are adjourned in Mr. Trimborn's cases. He'll be processed and he will be released today unless he has a PO hold, which I believe he currently does.
No, I don't think so.
Oh, never mind. Then he will be released from here today unless something else is holding him. So he will be processed. I can't tell you what time.
I'll wait for you guys.
But he will be released.
Thank you, Your Honor.
He said he would wait at the jail for you if you're coming to pick him up.
We are adjourned in Mr. Trimborn's matter. Good luck to you, sir.
Good luck.
Next is John Evans appearing via Zoom.
Court will call 25 CF 2917, State of Wisconsin versus John Evans, appearances.
ADA Sam Smith for the state.
Attorney Adam Welch appears on behalf of Mr. Evans. Mr. Evans, is that you appearing?
In the
behind the door
jail,
there?
yes.
Okay. Mr. Evans is appearing by Zoom video from elsewhere in the jail. Mr. Evans, did they give you a copy of the complaint in this case?
Yes, I just received it.
Okay. Do you have a updated mailing address?
My address right now is 1819 Averett Avenue, but I also received mail at 1128 Marine View Drive, apartment 304.
Do you want to use the Aberg address as your mailing address for the court?
Yes.
Okay, thank you. I assume the court got that. Your Honor, we'll waive reading of the complaint at this time, and I'll note that Mr. Evans is eligible for a public defender.
I have reviewed the criminal complaint. I do make a probable cause finding as to the misdemeanors and enter a not guilty plea on Mr. Evans' behalf. State's position on bail.
State's requesting cash bail in the amount of $2,500, along with the conditions that the defendant have no contact with Diana F, DIANNA, last initial F is in Frank. No contact with any member of Diana F's family. A ban from the Madison Estates apartment complex on Moraine View Drive in Madison. A ban from the 1800 block of Frisch Road in Madison, it's FRISCH. And I would ask that if the defendant does post cash, that he be referred to pretrial services for GPS monitoring, and for that to be fitted prior to his release from the jail. I'd also request the court to make findings under Wisconsin statute 940.47 based on information in the criminal complaint. Based on that finding, I would request a order under sub 1 of that statute that the defendant not violate Wisconsin statute 940.42 through 940.45, more specifically refraining from intimidation of the victim. And under 940.47 sub 3, that the defendant not be within 1,000 feet of the victim or any member of their family at any time. And under sub 4, the defendant not communicate with the victim or any family members except via an attorney or under other reasonable restrictions the court imposes. I would note in support of the cash and conditions, the defendant is charged with multiple Act 3 offenses. The victim has repeatedly expressed how fearful she is of the defendant in regards to the threats to both harm her and family members. The defendant refused to turn himself in when he spoke with law enforcement. He's from Chicago. And in recordings or conversations with the victim, there were conversations about being in Chicago or going there. So with the total amount of exposure, the Act 3 analysis, and the other factors that I've discussed, along with the limited ties to the Madison area, I think significant cash bail is appropriate. Thank you.
Counselor.
Your Honor, Mr. Evans does currently reside in the Madison area. He, I would start out by noting here that all the allegations against Mr. Evans are from June and July of this year. And the district attorney's office did not file any charges against him until December, when they issued this case with a warrant on the 22nd, so just a week ago. And then that warrant was served on the 27th. So there appears to be no indication that this alleged behavior has resumed or has been ongoing since July, which I think definitely undercuts any arguments the state may have based on there being some sort of ongoing threat or concern about intimidation or harassment or anything like that. This is very dated allegations at this point. There's nothing in the record here about any criminal record that Mr. Evans has. He's almost 40 years old. I've heard nothing about any failures to appear. I understand with the type of allegations here that keeping and ensuring a no contact is important. And I think the requirement that he wear a GPS bracelet for the time being and be banned from certain geographical areas is a reasonable way to assure that those conditions are being abided by. But I don't see why a cash bail would be necessary on this record. So I'd ask the court to issue a signature bond with the condition that he comply with pretrial services.
The defendant is charged with multiple felony charges with repeated contact violations through different means. which result in the stalking and other felony charges, many of which are, actually, I think all of which, except maybe, yeah, are Act 3 eligible offenses. Given the repeated violations that are alleged, I do believe some cash bail is necessary to protect the victim in this matter, and to assure Mr. Evans' appearance at future court dates. I will set cash bail in the amount of $1,000. I will order no contact with Diana F. or her family. A ban from the Madison Estate Apartments on Moraine View. A ban from the 1800 block of Frisch Road in Madison. If Mr. Evans is to post, I will order a GPS through pretrial services and it be fitted prior to his release. And under WISSTAT 940.47, I will order that regardless of whether or not you sign your bail form, you are not to have any contact with the victim or her family, because knowing and malicious prevention or dissuasion of a victim has occurred or is reasonably like to occur. I will order that you have no contact within 1,000 feet of the victim or her family, and that you have no communication with the victim or her family except through an attorney. If you violate these no contacts, you can be charged with separate violations. You need to make sure that you comply with these court orders as prescribed. Time limits as to the preliminary hearing, counselor.
We'd request a timely preliminary hearing, please.
The preliminary hearing shall be timely scheduled. We are adjourned in Mr. Evans' case.
Next is Ryan Peterson. Ryan Peterson.
Court will call 25 CF 2537, State of Wisconsin versus Ryan Peterson. Appearances.
ADA Sam Smith for the state.
Attorney Adam Welch from the Public Defender's Office with Mr. Peterson. He appears in person and in custody. We have received a copy of the complaint. We will waive its reading. The address listed on the complaint is accurate, and Mr. Peterson does qualify for a public defender.
I have reviewed the criminal complaint. It alleges 3 felony charges. State's position on bail.
State's recommending a signature bond, a ban from 6518 Milwaukee Street in Madison. No contact with the individuals with the initials AZC, BLC, JMF.
Is that JM or N?
JM is in Mary for the middle initial. JAC, JEG, OLK, MJL, and lastly RRM.
Any objection?
No.
I will then order a signature bond for Mr. Peterson. I will order that you are banned from the 6518 residence on Milwaukee Street. I will order no contact with AZC, BLC, JMF, JAC, JEG, OLK, MJL, RRM.
That's correct.
Time limits as to the preliminary hearing, counselor.
Or waive them.
Those are waived. A status conference shall be scheduled. Good luck to you, Mr. Peterson.
Next is Joseph Woods.
Court will call 25 CM 3080, State of Wisconsin versus Joseph Woods. Appearances.
ADA Sam Smith for the state.
One moment, please. I don't think so. Whatever. Mr. Woods appears in person and in custody with attorney Adam Welch. We have received a copy of the criminal complaint. We'll waive its reading and stand mute to the charges. Mr. Woods would be using the job center at 1819 Aberg Avenue, Madison, Wisconsin, 53704 as his mailing address right now. Currently, I'm showing that he does not qualify for a public defender. I think that's probably wrong, and I've talked to Mr. Woods about trying to get that straightened out.
And I'll note for the record, he's being handed a public defender application form so that he can make sure to apply for the public defender appointment. I have reviewed the criminal complaint. I do make a probable cause finding. I'll enter a not guilty plea on Mr. Woods' behalf to these charges. State's position on bail.
State's requesting cash bail in the amount of $150, along with the condition that he be banned from Portillo's. Reason for the cash. It's like in a previous case, Mr. Woods had cash bail reduced to a signature bond on October 15th of 2025. And now picking up the new case while on bond. I'll also note failures to appear January 24th, 2022 and November 21, 2019. Thank you.
Counsel.
1 second. Right. Your Honor, I would note that those failures to appear are a bit dated. I know he has other pending cases right now where he has been compliant with appearing as directed. I don't think there's a risk at this point that Mr. Woods would not appear voluntarily for court. He is a longtime resident of this area, and he currently is unemployed and would not be able to post even the modest amount that the state is recommending. So I would request a signature bond on his behalf.
There are misdemeanor charges. The underlying first count is a disorderly conduct. He does have pending cases. He's got failure to appears, which are rather dated. I am going to give Mr. Woods the opportunity to appear on his own recognizance. I'll give him a signature bond. I will order that you are banned from the Portillo's and that you are not to possess or consume any alcohol during the pendency of this action. We are adjourned in Mr. Woods' case.
All right. Make sure you call the public defender's office.
Next is Logan Conway. Mr. Conway. Please stand and tell us.
Court will call case numbers 25 CF 2984, 25 CF 2985, 25 CM 2414, 25 CM 2901, and 25 CM 3075, all for initial appearances. State of Wisconsin versus Logan Conway. Appearances.
ADA Sam Smith for the state.
Thank you, Your Honor. Adam Welch from the Public Defender's Office appearing specially with Mr. Conway for today's hearing only. Mr. Conway has retained Attorney Peter Bartelt for this, I believe, for all of these cases. Obviously, I'm not privy to exactly what their conversation was. It's Mr. Conway's understanding that Mr. Bartelt is going to be representing him going forward. But he is fine with me appearing specially for today's purposes, as Mr. Bartelt obviously is not here. With that said, we have received copies of all the criminal complaints. We'll waive their reading, stand mute to the misdemeanors, and I will note that the address on the complaints is accurate.
I have reviewed the criminal complaints. As to the misdemeanor charges, I do make a probable cause finding, and I'll enter a not guilty plea on Mr. Conway's behalf. State's position on bail.
I'll start with 25 CF 2984. State's recommending cash bail in the amount of $1,000, along with the conditions that he have no contact with Carla C, CARLA, that he not possess any dangerous weapons, that he not possess any ammunition, that he not possess any BB guns or airsoft rifles. In support of the cash, I'll start by just briefly noting, I believe count 3 is Act 3 eligible due to the dangerous weapon enhancer. But more importantly, I think as to reason for cash, the defendant is now on his 7th or has 7 open cases in Wisconsin, several of which are felonies. The 5 initial appearances we're here for today, it looks like has picked up all of those cases within approximately the last 6 months. And it's repeatedly appears to be allegations of similar or the same behavior involving firing projectiles at civilians or moving vehicles in a way that disrupts things. Most importantly, putting the public at risk in several instances. Our bail conditions seem to have little to no effect on his ability to stop. For those reasons, the state feels cash bail is necessary. In 25 CF 2985, the state is again requesting $1,000 and a ban from Thundercat Fireworks and Smoke Shop, and no contact with the co-defendant Brady Wethal. In 25 CM 2414, the state is again requesting $1,000 cash, no use or possession of fireworks, and a ban from Old Stage Road. And I'll note in the case ending in 2414, there was an out of custody IA dates set on October 9th in which the defendant failed to appear for. In 25 CM 2901, state is again requesting $1,000, no dangerous weapons, a ban from the 4900 block of Commerce Court in McFarland, a ban from the 5200 block of Broadhead Street, also in McFarland, a ban from the 5300 and 5400 blocks of Valley Drive in McFarland, a ban from the 5100 block of Rustic Way in McFarland. And lastly, in regards to 25 CM 3075, the state is again requesting $1,000 cash, a ban from the 1600 block of Jackson Street, and that's in Stoughton, and that he not possess any dangerous weapons. I'll just conclude by mentioning my reason for cash is the same reason that I mentioned earlier, but I will just briefly summarize by stating I know this is largely reckless conduct that is resulting in a large amount of property damage, but I will note the defendant has picked up several felonies in the past 6 months, and I think cash bail is appropriate to ensure he complies with bond conditions and attends court in the future. Thank you.
Counselor.
Thank you. First of all, just to go over a few things here. Mr. Conway is a young man with no criminal convictions at this time. The state talks about him, picking up cases in this serial fashion. But the reality here is that every single one of these cases, except for one, has allegations dating from over the summer prior to August 26th, which is when his first case was filed against him. So this is not a case where he is charged, released, charged, released, charged, released. This is a situation where, due to, I don't know if it's, the time it takes to complete the investigation or the time it takes the DA's office to review, we're getting cases filed now stemming from allegations that occurred over the summer. So that's a very different picture than somebody who is kind of in this revolving door situation. This is sort of a bunch of allegations that are now sort of catching up with the system here and all coming to head at the same time. There is one allegation that contains a more recent violation date, and that's the one where there is a bail jumping charge filed. I know this is not the time or place to get into the merits of the case, but I will just say that it's a rather complicated situation with some circumstantial evidence, and that Mr. Conway does dispute some of these allegations, and that'll be obviously hashed out at a later time. But I think it's important to understand the actual, chronology of everything here. There was a case, this was the 25 CM 2414, where there was an out of custody initial appearance that was scheduled. It is certainly not clear to me from the record that I have whether Mr. Conway received actual notice of that court date, or whether he was served with notice of that court date. But be that as it may, the record shows that one day after the failure to appear at the initial appearance, a notice of retainer was filed. So whatever the situation was, it seems like he found out about it right away, retained counsel, requested an initial appearance. That's all in the court record. It looks like nothing was ever scheduled by the court, and that eventually Mr. Conway just went in and posted the bond. So that strikes me as a young man who is not trying to evade the court system, but is actually trying to make sure things are done the right way. He took at least 2 affirmative steps there, one in hiring counsel and another in just coming in and posting the bond when the court didn't schedule a hearing. He is currently a very young man. As I said, he's 19 years old. He's a local resident. He's lived in this county his entire life. He lives in Stoughton. He currently does not have the resources to post a cash bail. He's unemployed as of today. He does have a job that is supposed to be starting next week. So if he's able to be released, then he'll be able to have that stability and start earning some income. But right now he doesn't have the means to post a bail. I think, looking at the big picture here, some sort of monitoring is certainly appropriate to make sure he's abiding by these geographical bans, to make sure he is accountable and that we know where he is. But I don't think large amounts of cash bail like the state is asking for are necessary here for a young man with no record of criminal convictions. I think this is a case where he should be given a signature bond on these charges with pretrial services, and be given a chance to show that he can continue abiding by those conditions.
Mr. Conway has a number of cases pending. He's got cases in Rock County. He's got cases here. We've got 5 cases here for initial appearance. And as counsel pointed out, some of them are from this summer, but one of them is from recent conduct alleged in December. And looking at the failure to appear in 2414, he was given his initial appearance date when he was released from jail and then promptly failed to appear for that hearing. Ultimately, he does have $200 cash bail posted after the return of warrant on November 12th. Given all of that, given the Act 3 eligible status, protection of the public with the number of victims, and ability to appear is questionable with Mr. Conway, so cash bail is necessary. Starting with 25 CF 2984, I will set cash bail in the amount of $300. No contact with Carla C, not go armed with any dangerous weapons as prescribed by statute, any ammunition, any BB guns or airsoft guns. 25 CF 2985. I will set cash bail in the amount of $300. No contact. With the co-defendant Brady Wethal. No contact with the, what was the name of the fireworks store?
Thundercat Fireworks and Smoke Shop.
Thundercat Fireworks and Smoke Shop. In 25 CM 2414, I will set cash bail in the amount of $200. That's already,
You were answering my question.
that's already been posted. I will order that you not possess any fireworks and a ban from the Old Stage Road. In 25 CM 2901, I will set cash bail in the amount of $500. That you not go any armed with any dangerous weapons. That you are banned from the 4900 block of Commerce Court. 5200 block of Broadway.
Broadhead.
The 5300 to 5400 block of Valley Drive. And the 5100 block of Rustic Way, all in McFarland. And in 25 CM 3075, I will set cash bail in the amount of $300. That you not go armed with any dangerous weapons as prescribed by statute. And that you are banned from the 1600 block of Jackson Street in Stoughton. As to the two felony matters, counsel, time limits for the preliminary hearing.
One moment, please. We did the 10-day, we're under the 20.
It would be the 20 days by statute. I was intending to schedule it within.
Okay. We'd like them within the time limits, please.
Preliminary hearing shall be scheduled timely. We are adjourned on Mr. Conway's cases.
Next is Peter Sanchez. Sanchez, the paperwork is down the elements.
Court will call 25 CF 2983, State of Wisconsin versus Peter Sanchez. Appearances.
ADA Sam Smith for the state.
Attorney Adam Welch from the Public Defender's Office appears with Mr. Sanchez. He appears in person and in custody. We have received a copy of the complaint. We will waive its reading. The address on the complaint is correct. He currently does not qualify for public defender representation, although I will represent him for today's hearing.
I have reviewed the criminal complaint. I do make a probable cause finding as to the misdemeanors in count 2 and 3 and enter a not guilty plea on his behalf. State's position on bail.
State's recommending cash bail in the amount of $2,000, along with the conditions that he not operate a motor vehicle and not consume or possess any alcohol.
Counsel.
Well, Your Honor, I understand that I'm assuming that the basis for the cash here is the allegation that Mr. Sanchez knowingly attempted to flee from an officer. I think everything else in this case would argue against a cash bail. Mr. Sanchez is a long-term resident of the area. He lives at the address on the complaint. He's employed in town here. He seems to be somebody that has strong ties to the community. His prior offenses here are from 2008. So that's, over 15 years ago. I don't believe he has any record in the time being, have not heard anything about failures to appear or anything of that nature. I think despite the allegations here, a signature bond would be appropriate for Mr. Sanchez.
Given the number offense OWI, given the conduct as alleged when the officers contact the fleeing, gives this court pause to believe that Mr. Sanchez will appear for court without some cash bail. To assure that, I will set it as low as I think I can in the amount of $400. I will order that you not operate a motor vehicle while the pendency of this case, and that you not possess or consume any alcohol. Time limits as to the preliminary hearing, counselor.
Waive the time limits, please.
Time limits are waived. A status conference shall be scheduled. We are adjourned in Mr. Sanchez's case. Good luck to you, sir.
Good luck.
Next is Xavier Over. Hearing via Zoom.
Court will call 25 CM 3072, State of Wisconsin versus Xavier Over. Appearances.
ADA Sam Smith for the state.
Attorney Adam Welch appears in person in the courtroom, appearing by Zoom, I believe is Xavier Over. Is that you appearing? Can you hear us? Mr. Over, is that you?
Yes,
And can you hear everybody okay?
yes,
Did they give you a copy of the new complaint?
yes, they have.
Okay. And would you still be using the beacon to get your mail?
Yes,
All right, thank you. Your Honor, we will waive reading of the complaint, stand mute to the charges. The address on the complaint is accurate.
I have reviewed the criminal complaint. I do make a probable cause finding. I will enter a not guilty plea on Mr. Over's behalf. State's position on bail.
State is recommending cash bail in the amount of $1,000. Along with the standard conditions. In regards to the cash, it appears this defendant recently bailed out on a signature bond the day prior to the incident date for this offense for a case involving similar conduct of alleged public masturbation. I would note he's charged as a repeater here, both charges. There has been numerous arrests for public masturbation. Mr. Over has proven that he's incapable of following bond conditions or the simplest bond condition to not commit new crimes. For that reason, the state feels cash bail is needed to ensure both his compliance with pretrial orders and that he returns to court. I would also note, while cases like these could resolve in a variety of ways, with there being a lewd and lascivious charge, and as I mentioned, the repeaters, there is increased exposure. So I think $1,000 cash is appropriate.
Counselor.
Well, Your Honor, the question here is whether Mr. Over will appear in court. And although Mr. Over has had numerous cases in Dane County over the last few years, according to CCAP, I was not able to find a single failure to appear in those cases, at least over the past 3 years. So I think this is a case where cash bail is not necessary to assure his appearance in court. It appears that he does appear. I know there have been some competency concerns in the past, but Mr. Over has appeared in court. He is a consistent resident of this community. And although I, can understand frustration at the nuisance aspect of this, the question before the court today is not what to do with Mr. Over in the grand scheme of things, but whether he's likely to appear in court. And the record clearly shows that he is. So I would request a signature bond on his behalf.
Looking at the conduct that's alleged in regards to it occurring the day prior, in an allegation, and then subsequent day, the non-compliance, the statements by Mr. Over attributed to him in the criminal complaint, especially when he's under arrest and his statements are, I'm just trying to fuck. This is annoying. Do you know any girls?
Not say that. I did
Given
not
all
say
of that information as alleged in there, I do believe some cash bail is necessary to assure Mr. Over's appearance at future court dates. I will set it in the amount of $200. I will order a ban from the 2500 block of Royal Avenue in Monona. We are adjourned in Mr. Over's case.
Next is Dale Sheriff for a forfeiture. Sheriff.
Protocol 25 FO 2565 Dane County versus Dale Sheriff. Appearances.
ADA Sam Smith for the county, defendants here in person and in custody.
Mr. Sheriff, I have what some consider good news. The police department referred up criminal charges against you. The DA's office reviewed those police reports and decided not to charge you criminally. Instead, they've charged you with an ordinance violation. In this case, it's a domestic county disorderly conduct charge. Regardless of your plea in this case, if this is the only thing holding you, you're going to be released today. Sometimes it's a case that can be resolved today. What is the county's offer for resolution?
That would be court costs only.
In this case, it looks like Mr. Sheriff is also being held out on probation.
This case is not going to hold you, but the probation hold is going to hold you. But if you wanted to plead guilty or no contest to this county disorderly conduct, I would find you guilty. I would assess court costs only of $214.50. You'd have time to pay that and it would take care of this case. If you want to plead not guilty, that's absolutely right. And this case could get set for further proceedings. How do you wish to plead to this ordinance violation?
So pretty much if I plead guilty to the disorderly conduct, it'll be
$214.50.
Yeah, I plead guilty to the disorderly conduct, but I don't understand, what is that for the battery?
Nope, there's no criminal charge out of this. You've only been charged with this ordinance violation of disorderly conduct unless there's a different case pending.
Mr. Sheriff was originally booked in on a battery in DC. It looks like they elected to only charge out the DC as a forfeiture.
So they're not going to charge you with that battery charge or the criminal disorderly conduct. They're only charging you with this ordinance violation.
Alright, yeah, that's fine. I plead guilty to it.
I'll find you guilty. I'll assess court costs only of $214.50. It takes care of this case. You'll have time to pay. Good luck to you, sir.
Sweet, sir. Next is Fontaine Dillard.
Protocol 25 CM 3082, State of Wisconsin versus Fontaine Dillard. Appearances.
ADA Sam Smith for the state.
Attorney Adam Welch appears with Mr. Dillard. He appears in person and in custody. We have a copy of the criminal complaint. We'll waive its reading. We'll leave the only, yes, so we'll stand mute to the one charge that applies to Mr. Dillard. The address on the complaint is accurate, except it should have apartment 2 added on to it. 6804 Tottenham Road, apartment 2. Pardon? Yeah, got it. And he does qualify for a public defender.
I have reviewed the criminal complaint as to count 1 against Mr. Dillard. I do make a probable cause finding and enter a not guilty plea on his behalf. State's position on bail.
State is recommending a signature bond along with the condition that he not consume or possess any controlled substances without a valid prescription.
Any objection?
No.
I will then enter a signature bond and order that you not possess any controlled substances or drug paraphernalia without a valid prescription during the pendency of this action. Good luck to you, sir.
Thank you. Sir. Next is Robert Hill. Robert Hill. 30 miles. 30 miles.
Court will call 25 CM 2598, State of Wisconsin versus Robert Hill, appearances.
ADA Sam Smith for the state.
Adam Welch with Mr. Hill. He appears in person and in custody. We have received a copy of the complaint. Right address right now. 53509 or 90. In the apartment or anything? Okay, right. The updated address for Mr. Hill is 109 Park Street, Sun Prairie, Wisconsin, 53590. Mr. Hill has not been evaluated for a public defender yet on this case. I got it. I'm handing him the form for dealing with that. Here, just take this.
I have reviewed the criminal complaint. I do make a probable cause finding. I will enter a not guilty plea on Mr. Hill's behalf. State's position on bail.
State's recommending a signature bond along with the condition that the defendant have no contact with First Student Inc.
Any objection?
No, that's fine.
I will then give Mr. Hill a signature bond. I will order that you not have any contact with First Student Inc. during the pendency of this action. Good luck to you, sir.
All right, Mr. Right, next will be Jennifer DUBEK, is hearing via Zoom.
Isn't this an ordinance or?
Yes.
Okay.
Court will call 25 FO 2564 Dane County versus Jennifer DUBEK, appearances.
Sam Smith for the county, defendants appearing via Zoom in the Dane County Jail.
Ms. DUBEK, you've been charged with an ordinance violation. The police department referred up criminal charges. They decided.
She was displaying dual middle fingers at us, talking quite a lot, and she had just walked away, but she's now back.
We are entering a not guilty plea on Ms. DUBEK's behalf, and the case will get scheduled for further proceedings. We are adjourned.
Next is Matthew Bradley. Matthew Bradley. Standing Rolex.
Yes, sir. Court will call 25 CF 2978 State of Wisconsin versus Matthew Bradley, appearances.
ADA Sam Smith for the state.
Mr. Bradley appears in person and in custody with attorney Adam Welch. We've received a copy of the criminal complaint and we will waive its reading. For a mailing address for Mr. Bradley, he has 3024 County Road A in Stoughton. Do you know the zip code? 53589. And he does qualify for a public defender.
I have reviewed the criminal complaint. As to the misdemeanor charges, I do make a probable cause finding and enter a not guilty plea on Mr. Bradley's behalf. State's position on bail.
State's recommending a signature bond along with the conditions that he have no contact with CLB and a ban from the Beacon, and that he not consume or possess alcohol.
Counselor.
That's fine.
I will then give Mr. Bradley a signature bond. I will order that you have no contact with CLB. You are banned from the Beacon, and you are not to possess or consume any alcohol during the pendency of this action. We are adjourned in Mr. Bradley's case.
Time limits.
Yep.
Let's waive them.
Those are waived. A status conference shall be scheduled. Good luck to you, sir.
Right, sir. Next is Scott Wishaw for a forfeiture. Mr. Wishaw. Paper, Senate yellow. Section.
Court will call 25 FO 2566 Dane County versus Scott Wishaw, appearances.
ADA Sam Smith for the county.
Mr. Wishaw, I have what some consider good news. The police department referred up criminal charges against you. The DA's office reviewed those police reports and decided not to charge you criminally. Instead, they've charged you with an ordinance violation for resisting or obstructing, similar to a parking ticket. It is not criminal. It's a municipal violation, and sometimes it's a case that can get resolved today. What is the county's offer for resolution of this matter?
That'd be court costs only.
In this case, looks like Mr. Shaw is also being held on a body only warrant for Waukesha County.
This case is not going to hold you in jail or in custody, but that body only warrant from Waukesha County is. If you want to take care of this case, you can plead guilty or no contest. I'll assess court costs of $114.50. You'll have some time to pay that. If you want to plead not guilty, that's absolutely your right, and the case can get set for further proceedings. How do you wish to plead to this ordinance violation?
Yeah, I'm not sure now, if I plead not guilty, what happens?
The case will get set for further proceedings.
Okay, now do I just have to stay in jail or?
There's a body only warrant out of Waukesha County, so Waukesha County is going to take you.
Oh, so I'm gonna get transferred? Okay, not guilty.
I'll enter a not guilty plea on your behalf, and this case will get set for further proceedings. We are adjourned. Good luck to you, sir.
Next is Colin Meyer for a forfeiture. Colin Meyer. This one. Stay on the double X.
Court will call 25 FO 2563 Dane County versus Colin Meyer. Appearances.
ADA Sam Smith for the county.
Mr. Meyer appears in person, in custody, and without counsel. We're here on an ordinance violation. I have what some consider good news, Mr. Meyer. The police department referred up criminal charges against you. The DA's office reviewed those police reports, decided not to charge you criminally. Instead, they've charged you with a county disorderly conduct, similar to a parking ticket or a citation. It is a municipal violation. Sometimes it's a case that can get resolved here today. What is the county's offer for resolution?
That'd be court costs only.
1450 in this case, I don't see anything else with Mr. Meyer.
Regardless of your plea in this case, you're going to be released today. But if you wanted to plead guilty or no contest, I would find you guilty. I would assess court costs only of $114.50, and you have some time to pay that. If you want to plead not guilty, that's absolutely your right, and this case would then get set for further proceedings. How do you wish to plead to this ordinance violation?
Sorry, I've never been like in court much before. This is a little confusing. So if I plead guilty on, is it 2 counts of threatening an officer?
None of that got
Just-
charged.
just
They didn't
order-
charge any of that. They've only charged you with this municipal violation for a disorderly conduct.
Guilty.
I'll find you guilty. I'll assess court costs only of $114.50. You'll have some time to pay that. Takes care of this case.
Awesome.
Good luck to you,
So
sir.
much.
Next is Cesar Ordonez Gonzalez.
Court will call 25 CF 2989, State of Wisconsin versus Cesar Ordonez Gonzalez. Appearances.
ADA Sam Smith for the state.
Is this where you'd be living? That's good. Yeah, right. Is that in, do you know the zip code there? Before? Okay. We have an updated address, sorry, Attorney Adam Welch appears with Mr. Ordonez Gonzalez. He appears in person. We've received a copy of the complaint. We'll waive its reading. The updated address would be 6 Prentice Place in Madison, Wisconsin, 53704. And he does qualify for public defender.
I have reviewed the criminal complaint. I do make a probable cause finding and entering not guilty plea on Mr. Ordonez Gonzalez's to the misdemeanor. State's position on bail.
State's requesting cash bail in the amount of $500, along with the conditions that he have no contact with Darwin C, as in cat. Darwin is DARWIN. Also, no contact with Edina GR. That's EDENIA. Last initials are Gary Robert. And that he not possess any dangerous weapons, not consume or possess any alcohol, and not consume any or possess any controlled substances without a valid prescription. Reason for the cash request, what's being alleged here is the defendant possessing a loaded firearm and brandishing it at several random citizens that are complete strangers to him. Merely possessing the firearm is prohibited for the defendant due to his felon status. And it's the state's position that if he's willing to disregard that prohibition, then there is a valid concern that he would abide by bail conditions. So the state feels that's at least some cash is necessary. Thank you.
Counselor.
Your Honor, he is a local resident. I've not heard anything about, failures to appear or anything that would, suggest that he's a flight risk. He's currently unemployed and indigent and would struggle to be able to post cash bail in that amount. We'd either request a signature bond or a lower amount of cash in this case.
The underlying felony charge, there's a PSA report giving 3 out of 6, 3 out of 6. That's back from 2022. There's warrants issued in August of 2022. Cash bond was actually posted and forfeited from that appearance. He then posted $2,500 and failed to appear January 13th. He then was referred to pretrial services and had multiple violations. And ultimately had cash bond reverted and reinstated. Given the charges as alleged here, the severity of which and conduct alleged and the prior missed court appearances from 21 CF 2372, I do believe some cash bail is necessary. I will set cash bail in the amount of $400. I will order no contact with Darwin C, Adina GR, that you're not going to be armed with any dangerous weapons as described by, as delineated by statute, including firearms, that you not possess or consume any alcohol, controlled substances, or drug paraphernalia without a valid prescription. Time limits as to the preliminary hearing, counselor.
We'll waive them.
Those are waived. And a status conference shall be scheduled. We are adjourned in Mr. Adornas Gonzalez's case. Good luck to you, sir.
Next is Jason Juno for a forfeiture. They weren't, please stand on the elements.
Court will call 25 FO 2562 Dane County versus Jason Luno, appearances.
ADA Sam Smith for the county, the defense here in person in custody without counsel.
Mr. Luno, do you know I have what some people consider good news? The police department referred up criminal charges against you. The DA's office read those police reports, decided not to charge you criminally. Instead, they've charged you with an ordinance violation of county obstructing or resisting. Sometimes that's a case that can be resolved here today. This is a charge that's similar to a parking ticket or a citation. It is non-criminal. This case will not be holding you, but you do have a body only warrant out of Columbia County, so you will be taken to Columbia County. What is the county's offer in regards to resolution of this matter?
That'd be court costs only.
You pled guilty or no contest to county obstructing or resisting. I would find you guilty. I would assess court costs only of $114.50. You'd have time to pay that. If you want to plead not guilty, that's absolutely your right, and this case would get set for further proceedings. How do you wish to plead to this ordinance violation? I'll accept your no contest plea. I'll enter that and find you guilty. I'll assess court costs only of $114.50. Good luck to you, sir.
This way, right, this way. Next is Devlin White.
Bless you.
Sorry. Devlin White. Stand on the door.
Court will call 25 CF 2982 State of Wisconsin versus Devlin Lied, appearances.
ADA Sam Smith for the state.
Adam Welch with Mr. Lyde, if I could just have one moment. Mr. Lyde does appear in person and in custody. We have received a copy of the complaint. I'd like to update his address. He'd be using the job center, 1819 Aberg Avenue, Madison, Wisconsin, 53704, for a mailing address right now. As of right now, he does not qualify for public defender representation, but I will represent him for today's hearing.
I have reviewed the criminal complaint. It alleges one felony charge, state's position on bail.
State's requesting cash bail in the amount of $2,000, along with the conditions that I have no contact with Gabriel R. It's GABRIEL, last initial R as in Robert, and also a ban from Madison Metro buses and properties. Reason for the cash, we are in Act 3 territory. What's being alleged, the defendant committed an Act 3 offense, more specifically beating a victim with numerous punches based on what appears to be barely any provocation. For that reason, the state feels that cash bail is appropriate to protect members of the community using public transit. Thank you.
Counselor.
Your Honor, Mr. Lyde is currently employed. He does volunteer work. He has strong ties to the area. I don't believe there's any history of failures to appear. I think this is a situation where I think there's a line between under Act 3 imposing cash bail to protect versus to punish. And I think the state's argument here is basically because these allegations are significant that he should be incarcerated on a cash bail. This isn't a case where there's some sort of history of threats or some ongoing intimidation or some reason to believe that Mr. Lyde would pose a threat to this person or to other people in any articulable way. I think it's more of a these are serious allegations against him and he should be punished by being held in jail on a cash bail. I don't think that's an appropriate use of Act 3. So we would ask the court to impose a signature bond in this case. I do object to the ban from public transit. It's a public utility. I think the public should be allowed to make use of that public utility and not be banned from it.
In looking at the allegations in the complaint, which include video observation, as described by the officer viewing that video. This is a serious offense in regards to the conduct as alleged towards Mr. Lyde. Additionally, it is Act 3 eligible, and protection of the public does come into this court's determination on whether or not cash bail is necessary to protect the public. I will set cash bail. I will set it in the amount of $200. I will order no contact with Gabriel R. And I will order a ban from the Madison Metro bus and property, given that this is where the conduct is alleged to have occurred. Therefore, protection of the public again is the basis for that condition. Time limits as to the preliminary hearing, counsel.
We'd like a timely preliminary hearing. Thank you.
Time limits are not waived. A preliminary hearing should be scheduled for Mr. Lyde. We are adjourned.
Next is Stephen Johnson for an extradition hearing. Gonna need some time to speak to Mr. Johnson.
Yes, that'd be great.
We need Mr. Johnson to place this sign move.
Court will call 25 CF 2988, State of Wisconsin versus Stephen Johnson for extradition appearances.
ADA Sam Smith for the state.
Mr. Johnson appears in custody with Attorney Adam Welch.
We are here in regards to an extradition complaint being filed. Counsel, are we setting bail?
Yes, Your Honor.
State's position on bail.
The state is requesting cash bail in the amount of $1,000 in the standard conditions. I'll note the extradition complaint mentions the county of Winnebago in the state of Illinois, with the underlying crime being a retail theft. For those reasons, I think $1,000 is appropriate.
Counselor.
Your Honor, I've spoken with Mr. Johnson about this. He lives in Beloit. This is not like a long distance thing. He believes, based on his experience, that he should be able to get this warrant quashed and appear voluntarily if he's able to get released. He understands that a bond has to be set here. We're asking the court to consider setting it a bit lower than what the state is asking for, maybe a couple $100. It's a retail theft case that he believes he can get taken care of. He lives in Beloit with his mother. His mother is a cancer patient right now, stage 4, and he's anxious to try to be able to get this all cleared up so that he's able to be there with her to support her. So we're asking the court just to consider a lower amount of cash.
Given that this is a request out of the state of Illinois for their warrant and return to their jurisdiction, I will set cash bail in the amount of $1,000.
Okay, thank you, Your Honor.
We are adjourned.
All right, got just one of them. Next is J.C. Williamson. Williams. Please stand on your rights.
I don't. I see.
We'll call case numbers 25 CM 3085 and 25 CM 3086, State of Wisconsin versus J.C. Williamson appearances.
ADA Sam Smith for the state.
Attorney Adam Welch from the Public Defender's Office with Mr. Williamson. If I can just have one moment, Your Honor. We have received a copy of the criminal complaints, waived their reading. The address on the complaints is accurate, and he does qualify for public defender representation.
I have reviewed the criminal complaints. I do make probable cause findings as to all of the misdemeanor charges and enter a not guilty plea on Mr. Williamson's behalf. State's position on bail.
In each of these cases, the state's request is identical. In each of them, I'm requesting a signature bond, no contact with Brianna C. It's BRIANNA, last initial C as in cat. A ban from the 2000 block of West Broadway in Madison, and that he not consume or possess any controlled substances or drug paraphernalia without a valid prescription.
Any objection, Counselor?
No.
I will then order a signature bond. I will order that you have no contact with Brianna C. during the pendency of this action. You can't call, write, text, message, no contact whatsoever. You are banned from the 2000 block of West Broadway. You are not to possess or consume any controlled substances or drug paraphernalia without a valid prescription. We are adjourned to Mr. Williamson's.
How long is it?
That's everyone.
Luck to you, sir.